Last lecture, I discussed the various modes of selecting judges on both the state and federal levels. In this lecture, I want to first highlight some observations about those states. The roughly 50% of the country, 50% of the states, wherein judges are selected by popular election, either partisan election or nonpartisan elections. Second, I would like to make some general observations that apply to the selection of state court judges generally. And third, and finally, I would like to briefly address the issue of removing judges from the bench. For those states that select judges for the bench by popular election and by a vote of the electorate, we know several things. As a general matter, as great as elections might sound for selecting judges, as democratic as this might sound, we know in fact that voters know very little about judicial candidates and have very little information when they vote. This is the case for three different reasons. First, ethical rules, canons of judicial ethics, limit discussion of certain legal issues during a campaign. So even if there are campaign ads, and the candidate can afford those ads, these ads often focus on bland matters such as family life, previous employment experience, and maybe perhaps a slogan like "tough on crime." The Dayton Journal-Herald in Ohio in October 1980 ran an ad for someone running for a judicial position. The ad in large part was simply a picture of the candidate with his 3-year-old son, and the caption read, "Vote for my daddy." And then the ad went on to say that, quote, "My daddy will be a really good judge." And it then went on to include the fact that, quote, "My daddy takes really good care of me, my little baby sister Laura, and my mommy." Now, how useful is this ad as to whether or not the person would make a good trial court judge? Second, the lack of voter information of candidates is compounded by the fact that judicial candidates spend very little money campaigning and are, for the most part, very small-scale operations compared to the traditional political candidate. One study from California in 1982 revealed that judicial candidates for office spent 11 cents per vote versus $2 per vote spent by the average legislative candidate that very same year. Third, because of the general lack of information, individual voters must make a concerted effort to educate themselves on persons running for judicial office, for the bench. And for judges, that would logically include researching the types of cases they have handled, if it's an incumbent, and how those individuals ruled on the cases. Well, how many voters do you think do this type of legal research in practice? So in elections, it often comes down to a familiar face or a name. And if the state selects judges via the partisan election model, people often will just vote for a person based solely on the party affiliation. Party affiliation, when permitted on the ballot, then plays a huge role in the selection process, given the dearth of any other available information to the voters. People simply will vote the ticket straight down based upon the party they identify with. Thus, it's not surprising that one study found in partisan states, judicial candidates do the best in those counties wherein their party does the best in the gubernatorial race. This reminds me of a famous old quotation from a state judge about why he initially won election to become a state judge and then lost his seat 4 years later when he came up for re-election. This judge, a Democrat, said, quote, "I was elected in 1916 because Woodrow Wilson kept us out of war. I was defeated in 1920 because Woodrow Wilson hadn't kept us out of war. A third characteristic of election states, wherein the voters choose judges by ballot, is that there is a huge, clear advantage to the incumbents. Despite the quote from that Democratic judge who lost his re-election attempt in 1920 that I just indicated, most of the time incumbents are re-elected without very much effort. Almost once a judge, always a judge. Why? Well, again, given the lack of voter information that we've discussed, party recognition in partisan elections plays a large part and a large role in the process, and it's hard for someone to overcome that barrier. And people assume if you are a judge, you should remain a judge. One study found that incumbents in Ohio and Michigan over a 2-decade time period were re-elected 80% of the time. A fourth characteristic we see at play in election states is that the governor still looms very large over the process, which not necessarily makes sense. Why would a governor loom very large over an election process? Well, it makes sense if you consider this fact. In election states, if a vacancy occurs in between elections, it's typically filled by the governor. In fact, in one study, over a 2-decade time period, looked at judges in Ohio, and 40% of the judges then sitting as trial court judges had originally made their way to the bench by gubernatorial appointment, as opposed to election. And then, because of the lack of voter information, and because of the advantage to incumbents that we just discussed, these governor-appointed judges will then win their re-elections and simply remain on the bench indefinitely, unless removed based upon one of the removal options we'll discuss in a moment. So simply put, job security for sitting judges is high. On the federal level, judicial positions are for life, and judges only leave the bench when they retire, die, or are impeached. As with the impeachment for other officials under the U.S. Constitution, the House of Representatives must bring articles of impeachment, after which the person is tried by the Senate and can only be convicted by a 2/3 vote of the Senate. Impeachment charges may be brought for, quote, treason, bribery, or other high crimes and misdemeanors, unquote. Well, we've never had a Supreme Court justice removed by the impeachment process. However, in U.S. history, there have been 15 impeachment proceedings against federal judges. 4 were acquitted in the Senate, 7 were convicted by the Senate, and 3 resigned before a Senate vote. On the state level, 45 of the 50 states also allow for the removal of judges by a state impeachment process, which largely mirrors the federal process. Another method of removal on the state level is called legislative address. Legislative address, unlike impeachment, is not limited or reserved for high crimes and misdemeanors, and may be used in cases like incompetency, senility, or partiality. State-level judges may also be removed by recall. A recall begins when voters get the requisite number of signatures on a ballot. If a valid number of signatures are collected, for example, 5% of the registered voters, the judge in question must then face a retention election where voters are asked whether or not this judge should remain on the bench. Finally, there's an additional device utilized in some states to remove state-level judges through specially empowered judicial conduct boards. These are boards that are created to look at potential misconduct and issues of incompetence involving all the judges within that particular state, and are vested with the power to impose disciplinary action up to and including removal from the bench, depending on the severity of the conduct of the judge. Well, of course, you also have to consider in state courts where judges are elected and do not serve for life, judges could be removed through re-election and not winning the re-election. Although we know again from studies that incumbents tend to win their re-elections over 80% of the time when they run for re-election. So it's very hard to remove judges once on the bench. Federally, does not occur unless, again, there's a death, resignation, or impeachment. And then on the state level, we've just discussed the various ways in which judges may be removed from the bench. Although overall this is rare and job security is incredibly high, therefore, for judicial actors, both on the state and federal level.